Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Thank you guys, first of all, for tuning in to the replay gang. Thank you for checking it out. This is going to be the second part of the Blueface criminal and civil cases timeline. So, the first part, we went over all three of the criminal cases that Blueface either had or is still ongoing. Now we are going to cover the civil portion of it. So let's get into it. Now, before I get into his, I'm about to say criminal, his civil side of things, I do want to explain the difference between civil cases and criminal cases. And this is for those who don't understand how the process works. When you're dealing with civil cases, that involves disputes between people or an organization. You can still have a jury trial, but what will happen is they'll use evidence to make a finding of a civil liability, and then that results into damages. So, for example, slip and fall, car wreck, uh, defamation. Oh man, the list goes on. So those the civil suits pretty much settle civil liability as damages. So that's why people get a lump sum of funds, like with what we call a settlement. Criminal cases allege or alleges a violation of a criminal law. So when it comes to a criminal jury trial, they use evidence to make a determination of innocence or guilt. So if you violate a crime, if you unalive somebody, if you steal something, even when you're dealing with a car wreck, let's say somebody was drinking and driving, just like the dude out here in Dallas. So not only are you going to have a criminal portion of that, but you're also going to have a civil because you got to pay for medical bills, so on and so forth. So, but just to kind of help you guys, golly, I can't even talk. To give you guys a synopsis of the difference between the civil case and the criminal case, that's the best way I can explain it. I have gone on this here YouTube just to look at different things, listen to different point of views, because that's what I do. I'm a poli sci major by heart, so I love debate. I love listening to other people's opinions and things of that nature. But what I don't like is the misinformation because you're uneducated about the subject matter. With civil cases, this is not like a criminal case. So there's not a time where if there is a scheduled court hearing, they have to attend. The way litigation works is civil, on the civil side, we file a complaint, we get the defendant served or the respondent served, we give them time to answer or respond to the lawsuit. Then we go into discovery phase. I send over what is called uh, d- discovery. So a request for interrogatories, which is like a list of questions that they have to answer, a request for production if I'm asking for any photos, any videos, um, what else? Just anything in their possession that can help the plaintiff with their case. Once we do discovery, then we set up depositions. Now, depositions is where, so for us, I work on the plaintiff side. So we will depose the defendant. The defendant's attorney will depose the plaintiff. Then we get the transcripts, we read all the transcripts, then we go to mediation. With mediation, yes, the parties have to be present because now you're at the time to mediate the case. If we can't settle the case at that time, then we move on to jury. Well, to trial, I would say, where there is a jury. And yes, the plaintiffs and defendants present is required. So when you see things on the court docket talking about, a status conference hearing or things of that nature, the plaintiff nor the defendant has to be there. I mean, you can say, I'm telling a story. I do this on a daily. This YouTube, like I said, this is a hobby. But my profession outside of this is a paralegal working with attorneys in these civil and criminal matters. So I know the process. With criminal matters, it's different because you have violated the law. So if the judge requests for your appearance, you gotta go. But we still go through the discovery phase. Both sides look at the discovery. We set another hearing. You gotta go to that hearing, go before the judge. Then they might set it for a plea hearing. And, if you say, I'm not accepting that plea, then we're going to go ahead and go to trial. And you're going to take your chances at trial. That is the process. So civil is totally different than criminal. So as we see with Blueface, he has all of these criminal, and I say all, he has two active criminal cases, one in California, one in Nevada. That results obviously in jail time. On the other instance, he has civil suits, which will result in a settlement or a judgment that will stay on your credit and with the county forever if you do not pay that. So I wanted to clear that up. That is the difference between civil cases and criminal cases, okay? All right. So let's get into the main topic at hand. Just like for the criminal case, I did a little timeline for his criminal cases. Now, some of these you may not have heard of, and that's okay. But anytime you are involved in a lawsuit, I am still going to pull that up as what you see here. So the first one says SG Enterprise LLC filed suit against Blueface on December 29, 2022. That is the SG Enterprise is the owner of Euphoric's Gentlement Club, and everybody knows what happened in regards to that. That was the incident back on October 8th, 2022, when Blueface had the situation with Mr. Traylor and the powing and all this other stuff. So this civil suit resulted from that. If we go down, we have Jasmine Brooks filed suit against SG Enterprise. Once again, she filed suit against the owners. And Blueface on March 22nd, 2023. Mr. Traylor then filed a suit against Euphoric Gentlemen's Club, so aka SG Enterprise, on August 9th, 2023. Blueface was in that lawsuit. He was listed as a defendant. Jarvis Hurd filed a suit against Mr. Traylor, and Blueface was also a defendant in that case. They filed that on October 24th, 2023. And then the latest that we have filed, civil suit filed against Blueface, is Jackilyn Martinez, which is Soldier Boy's baby mother, the mother of his children. I hate saying baby mama, the mother of his children. And she filed that suit on December 22nd, 2023. So as of right now, he has a couple of lawsuits that is either directly suing him or he is listed as a defendant. Now, if we take a look at, excuse me, Jasmine, drinking a lot of water today. Jasmine, Mr. Traylor, Mr. Hurd, all of those three civil suits resulted from the incident on October 8th, 2022. Why that happens, I'm going to explain to you guys why. Anytime there is an incident, we call it premises liability. Okay. And luckily I'm working on two cases now. One for the plaintiff, the other one is for the defendant. So for the plaintiff, unfortunately, he passed away. So his mother filed suit on behalf of him, as well as the mother of his children and the children. And she's representing, or I shouldn't say representing, but filing on behalf of the children. So this is considered a wrongful death civil suit, but it's also premises liability. So what happens is, because there was a pow-powing and an unaliving of our client's son, we sued the owner. So in this case, SG Enterprises is the owner, and we sued the club. In Blueface case, that would be Euphoric Gentlemen's Club. So for us, I sued the owner, I sued the Gentlemen's Club, because everybody's like, why would you do that? Why do people do that? Because they have a duty to protect all invitees in that establishment. Where was security? If you had security, none of this probably would have went down. But who knows? Security was probably there. I don't know. But they are entitled to file suit, because that's like you going to Walmart, or you going to the movies, or you go into a car dealership. You are expecting to be safe, correct? So if something was to happen, what do you think people do? They end up suing the owner of the building the establishment that they were in, and they're going to sue them for damages, emotional damages, physical damages, mental, all type, whatever damages you can get out of, you can sue for. But you can only do civil suits, because there's no criminal activity that, how can I say that? I mean, it can derive from it, but when it comes to damages, is something that you have to look at. So what you're going to see is, and I'm going to look at Euphoria, and I'm going to look at Jackilyn, and I want you guys to understand what damages are, because it could be something totally, um, I don't want to say different, but it's it's torts. And you know what? I'm speaking legal genre. I'm gonna find a different word to use for that. But without further ado, I'm going to go straight to the court docket so we can look at each of these lawsuits. So the first one being SG Enterprise LLC. They are the owners of Euphoric Club, so they are suing Blueface, and we pretty much know why he ended up suing them, because you know they lost some money. They had to eventually shut down. So all right, so I brought that up. I'm going to put in the first. Give me a second because I need to copy and paste. Okay, so this first case is the SG Enterprise against Johnathan. This is the one where they obviously had the 13 million. Who that man there? All right. So here, as you can see, it has the judgment. The judgment was rendered on October 21st, 2003, and the total judgment amount of 13 million. Ooh, $72,482. The judgment was rendered on October 21st, and it was docketed on 3rd. And I'm just kind of scrolling down here. Okay, as you can see, they didn't go to trial on this. I want everybody to understand that they did not go to trial. What they did was they filed a motion for summary judgment. And then let's see, that was actually vacated. So, kind of going up. They filed a supplemental motion for summary judgment. All right, either way, the case was settled for that amount. So I want to go and share the PDF because I want you guys to be able. Okay. Almost forgot to share the screen. Hopefully everybody can see that. Okay, so this is the original petition that they filed. Let's see. I don't want to go through all of this, but these were the allegations. But I want you to pay attention to certain things. So remember when I was talking about, when you go into an establishment, you expect to be safe. That is the duty that the owners as well as the club is supposed to provide invitees. So it says on or about October 8th, 2022, defendant visited the club with several of his acquaintances. Upon information and belief, an unidentified patron entered the club and encountered defendant's group inside, resulting in an altercation. Upon information and belief, following the altercation, defendant and the other parties involved exited the club. Upon information and belief, defendant's group was standing outside the club on the sidewalk when a vehicle driven by the unidentified patron involved in the prior altercation stopped on the street in front of the club near. Upon information and belief, the unidentified patron and defendant continued their altercation, whereby defendant removed a firearm from his person, that means himself, and fired several shots or pow-pows at the unidentified patron and injured a bystander. So not only did Mr. Traylor get injured, also an innocent bystander. And that's why we have the civil suits. Let's see. Plaintiff, in its operation of the club, took all reasonable, prudent measures to ensure the safety of his patrons, including but not limited to the postage of signage indicating that firearms are prohibited on the premises. So, pretty much what you're going to see here is the club and the owners saying that they did everything. They did their due diligence to ensure that all patrons, invitees in the club was secured. How they secure them? The first one, they posted signs saying that there's no firearms allowed. They also said they had metal fire detectors. They conduct Now, you conducted a pat down, but you didn't fill the the whatchamacallit, that's crazy. Use wands, maintain security cameras, and use in-house security for the club. Upon information and belief, defendant has a criminal history involving firearms. Upon information and belief, a direct result of the incident that occurred on or about October 8, 2022, defendant has been charged with attempted unaliving with a use of a deadly weapon and at least one other crime. So what they did was they took the criminal lawsuit and embedded it into a civil petition and said, hey, look, this dude is known for, having firearms. Look what happened at our club on, October 8th. He was charged with it. So they're trying to plead their civil case. So because all of this happened, the club's license were revoked and suspended on October 14th. So that was 6 days after the incident happened. Now, not if we go back up here, it shows you everything, all the license that they have. They have a license for adult entertainment, cabaret, the liquor license, hookah services, and admin and support services, meaning the security company. Now, they lost all of their license. They were revoked or suspended on this date. So because of that incident, they were forced to close. But for the defendant's negligence, willful, and reckless conduct, the club will still be in operation today. So what they're trying to say, if Blueface never showed up and never caused that altercation, that they would still be in operation. On November 18, 2022, the law firm of Gina Carrera and Associates served upon plaintiff a letter demanding the preservation of evidence in connection with Jasmine Brooks, who was allegedly injured at the club on the night of the incident involving defendant. So, and we're going to get into that. So, Jasmine filed a lawsuit. So that's a plaintiff. So remember what I told you guys when it comes to what is it called, discovery. So anytime we represent somebody, the first thing that we do is I will send out a letter of representation. So when it comes to not so much car wrecks, but if it's car wrecks involving commercial vehicles or trucking companies, or if it's a facility, a slip and fall, or nightclub in this matter, not only am I going to send over a letter of representation letting them know that we are representing this individual, the plaintiff, but I'm also going to ask that you preserve evidence. So that means surveillance cameras, any, anything that is tangible or intangible that we can use, we need you to preserve it. If you fail to do so, that will result in legal actions. So she was right. They were right to send off that letter to them. So she did that on November 18th. I forgot exactly when she filed suit, but they were on it. Let's see. So because of the incident, plaintiff has suffered damages in excess of 15,000 as a direct result of the suspension of its license and subsequent closure of the company. So these are just the things that they sued for. They sued for nuisance. So your boy is a nuisance in these streets. Plain and simple. He came to the club and did all of that. He's considered a nuisance. And indemnification and contribution. So pretty much, let's see, because defendant's negligent, willful, and reckless conduct, plaintiff was contacted by counsel for Jasmine Brooks, who is alleging she sustained injuries at the club during the incident involving the defendant on October 8, 2022. If a judgment is rendered against plaintiff in connection with the injuries alleged sustained by Jasmine Brooks on the night of the incident, plaintiff is entitled to equitable indemnity apportionment of the liability and contribution from defendant by way of sums paid by settlement or any alternative judgment rendered against the plaintiff. So that means, how can I say this? So, and you're going to see this. Jasmine files suit. If Jasmine gets a settlement, because she filed suit against the owners of the club, if she wins that, then they have to pay her. That's what it's saying. They have to pay her. So therefore, because they have Euphoric or SG Enterprises have to pay Jasmine, that means more money needs to come from Blueface. Because remember, he already got a settlement. I didn't even say a settlement, a judgment. 13 million plus. So they're not saying out of that 13 million, we're going to pay Jasmine. No, we need an additional whatever, because now we have to pay Jasmine if she wins this lawsuit. Third claim, third claim was a declaratory relief. They pretty much saying, let me see. Plaintiffs asked the court to determine the parties' relative rights and to declare that the plaintiff may proceed against defendant Porter for damages as a result of defendant Porter's actions as a direct and proximate cause of defendant's wrongful conduct. Plaintiff has suffered damages in excess of 15,000. Now, I do want to be clear with everyone. This is not saying that they were asking for 15,000. What happens is when you are in certain courts, hear different amounts. So for instance, a small claims court is not going to, and I'm going to use Texas as an example. For small claims court cases in Dallas, the courts do not hear anything over 20,000. So if you go to a small claims court, the most you're going to get is 20,000. If you are looking for anything above that, then you have to go to district court. So district court will hear anything over 20,000. So for me, if I was drafting this petition for a small claims, I would put I think the minimum would be 10,000. So I would say has suffered damages in excess of $10,000 but lower than $20,000. So this is not saying that this person is asking for, or this entity is asking for $15,000. It's just simply saying that the cost is going to be more than the $15,000. So this particular court that they filed in hears cases of more than $15,000. Okay. So if they were asking for anything less than that, then they wouldn't even be in this particular court. It would be a different court. All right. Um, so here, once again, they had their claims for nuisance. They had their claims for indemnification and contribution. In the event that Jasmine Brooks have to recover from the plaintiff, SG Enterprise and Euphoric Gentlemen's Club, and then declaratory judgment. And then whatever fees and costs that is associated with that. So with that going into, here is the judgment. Now this is before Jasmine's case. So we're going to get into that. So here is, and I'm not going to read all of that, but the judge did order this. He said that the plaintiff this is what they submitted, but the plaintiff was seeking damages, including damages for lost revenue and lease damages in the total amount of $13,072,482. Here is the breakdown. Lost revenue, 12.6 mil. Lease damages, 198,000 from October 2022 to September 2023. Because even though the club is shut down, they are still obligated to pay rent and everything else that is associated with that. Plaintiff damages in the amount of $240,159 arising from utilities, unpaid payroll to the employees after the closure, sales tax, insurance to cover the vacant building, cleaning security, internet for the property, triple net landlord expenses, including property tax, annual sewer service, repair and maintenance, supplies, trash services, liquor, leases for carbon dioxide, and I hope that's carbon dioxide, CO2, and POS, and unrelated legal fees. Plaintiff's damages in the amount of $34,323 for the following pending invoices, including invoices for triple net lease for property tax, sewer service, repair, maintenance, fire service, rental late charges, utilities, more utilities, lease renting, of the metal detectors, ice machines, and ATMs. So Blueface had to cover all of this. So in addition to that, attorney's fees, cost, prospective attorney fees and costs. This is bananas. So this is what he now has over his head. So not only are you dealing with criminal battles, but you are also dealing with civil battles. You have a 13 million plus judgment that you are not going to be able to get rid of. I have a case that I am currently working on. I was able to get an ex football player $66,000 back. We gave the individual 30 days to pay that judgment before it start accruing interest. He didn't pay it. So then I went ahead and I filed a writ of garnishment so we can freeze the bank accounts. I just got that granted last week. And funny thing, dude called and we was all on three-way and he was like, "Is there anything that I can do to get rid of this? I'm just trying to figure out how to pay dude his money. What can I do?" And I told him the best thing you need to do is you need to get an attorney. Because at this point, we filed suit last year. You were served a copy of that lawsuit. You failed to respond. So I submitted a default judgment and the judge granted that. But now your bank account is frozen, you want to take action. I'm not wishing bad on anybody, but at the end of the day, take care of your obligation. Don't wait till the last minute when something happens, because this Blueface, this is a judgment. Look at Tasha K. She's trying to do everything in her power to not pay Cardi B her money. And you can't do that. You just can't go out and file for bankruptcy. I feel bad for you, but at the end of the day, you have to be careful. You have to be careful. If you find yourself in a civil lawsuit and you don't respond to the petition and end up in a default judgment, or you're like Blueface and it ended up in a $13 million, that's more than Tasha K. There's no way you can get out of this civil judgment. You can't file for bankruptcy. A lot of people think that you can file for bankruptcy, and that is not the case. Well, I'm going to take that back. Everybody, you can file for bankruptcy all day, but you have to present documents. You have to fill out schedules. Do you know how many schedules there are? How many forms in a bankruptcy package? That's one service I do not do. I did it one time and I said I'm not doing it again. I don't care how much you pay me. That is time consuming. But what I'm trying to say is you have to give bank statements, uh uh, W-2s or tax returns, you have to literally show that your income is less than your liabilities. And even if you do that, it's not always that the judge will grant you bankruptcy. So Blueface can't just be like, oh my gosh, I got $13 million plus, I'm going to go ahead and file for bankruptcy. Nah, bruh. It don't happen like that. It does not happen like that. All right. So I showed you guys that. Let me go ahead and so that is that's the first civil suit. That is the first civil suit. So now we're going to go to nope. Let me pull it up. I'm sorry, y'all. I have to make sure I show the correct screen. Are we going to be in trouble? All right. So that is the owners with that 13 million plus judgment that is over Blueface's head. He can't get rid of that. He cannot. So leading into that, we are now going to look at Jasmine's. Now, I do not have her petition. I am trying to get access to that. So hopefully I can have more information. I'll probably do another one, but that's okay. But I just want to give you guys a look at the docket. So she filed on March 22nd, and once again, negligence, premises liability. So she was an innocent bystander at that club. SG Enterprises, Euphoric Gentlement Club failed to protect Jasmine. She ended up with injuries, which resulted in her having to seek medical attention. Now you have all these medical bills, and we don't know because I don't have the complaint in front of me of, what all happened, but I'm pretty sure you have medical bills, pain and suffering, emotional distress. All of that takes a toll. All of that takes a toll. And she does have a right to sue the club, including Blueface. So here is the plaintiff, here is the defendant. So she sued the club, the owners of the club, Blueface, and they actually had an arbiter, which means that they mediated the case, which is a good thing. So she received the judgment on March 4th, 2024, but here, unlike the SG Enterprises case docket, you don't see how much she settled for or they came to an agreement for. But that judgment was entered on March 4th and it was docketed on March 5th. Let's see, it says order of dismissal with prejudice. So that means because they came to an agreement and a settlement, they can dismiss the case with prejudice, meaning that she cannot come back and sue the club. Okay, that's what with prejudice means. You can't come back and you cannot sue the club because you already settled. And the creditor is SG Enterprises. So that's why they put that in their complaint, that in the event she wins, they should not have to pay out of their judgment, but whatever her amount is, it should be added to their judgment so that way they can pay her. So that means instead of Blueface just paying the judgment for SG that 13 million plus all that other stuff, he also has to pay whatever amount they came to in that mediation. So that's it. So for Jasmine, she has settled her case. How much? We don't know. And I'm definitely trying to figure that one out. That would be nice to know. All right, so now let's go on to the next person who filed in that same county. This is actually Mr. Traylor. So the victim, he also filed a civil suit. And here he filed on August 9th, 2023. He filed for negligence. He sued the Gentlemen's Club and Blueface. So complaint was filed. Let's see. Summons was issued. So summons was issued on Blueface on August 9th. Let's see. Affidavit of due diligence. So they did that. They were served. Ooh, motion to withdraw as counsel for plaintiff. So it looks like on January 3rd, 2024, whoever Mr. Traylor's attorneys withdrew from the case. Well, filed a motion because remember, we need an order saying that they can go ahead and be removed from the case. Let's see. Ex parte application for order shortening time for hearing. So this is just saying when remember when they file a motion, you got to get a hearing. So what they did was they were like, look, we please don't set this hearing out in a month's time. We need a date within the next 2 weeks or the next couple of days. So they want to shorten the hearing time. That's all that is. Let's see. And they got that. They filed that on the 3rd. On the 18th, they had their hearing and the order was granted. So he did not, well, the attorney removed themselves from the case. Let's see. They had audio-visual transmission equipment show cause hearing, Zoom conference, show cause, and that's it. And so your boy got new counsel on May 21st. Cox and Wilson's notice of appearance on behalf. So they really had to. All right. So the show cause, they had to give Mr. Traylor time to find new counsel. So that's the show cause hearing for. And May 21st is when his new attorneys went ahead and filed a notice of appearance. So now he does have counsel, but that's all that has happened on this case. So this case is still open, and I'm just kind of seeing. And honestly, Blueface was never served. That's the summons, affidavit of due diligence, and affidavit of service. Another affidavit of service. Blueface hasn't been served yet on this case. So that's the holdup. He got to be served. These people dodging service is so crazy. All right, so our next case is Mr. Jarvis Heard. He was also one of the patrons at the Euphoric Gentlemen's Club. He filed his on October 24th, 2023. This is a negligence premises liability case. He is suing Mr. Traylor, Blueface, the Club, and Eugene Rotondo. Don't even know who that is. Figure it out. Ooh, and Shannon Sanders. I don't know none of these people. I have to do some more investigation. So he filed his and he also demanded jury trial. Summons were issued on the 24th. Affidavit of the service. So Traylor was served. SG Enterprises was served. SG Enterprises filed their answer, which is good because anytime you're served, you got to file an answer. And the answer was for SG Enterprises. The Gentlemen's Club, Eugene Rotondo. So I'm assuming that they are probably the managers, supervisors. So whoever the attorney is for these defendants, they answered on behalf of them. Initial appearance, affidavit of for Porter, affidavits of attempts. So they attempted to do Sanders and Rotondo. Now here, I am assuming it says affidavit of service. So Mr. Jamall was, I call him Jamall, Johnathan was served on January 9th. Oh yeah, he was served on January 9th. Whoever his attorney was filed an appearance on January 10th. Oh, that's lovely. And right now they tried to, now that's weird. So I guess they didn't. So here it just shows order of service by publication. So anytime you're unable to serve somebody through a process server, constable, or sheriff, you have to actually serve them by another means. So the next substitute would be by publication, which means that they have to post an ad either or in a newspaper or like an online newspaper for a certain amount of weeks, and if nobody responds to it, then that will be accepted as service. So they are still trying to serve this person. And I'm just kind of going through here. So they are really trying to settle this. And it says arbitration. Really, I call it a mediation. So they had a mediation via Zoom on March 1st. And here are the attorneys. Let's see. The ad ran in the newspaper, and this is the proof of service. So Jonathan's attorney withdrew on April 5th, 2024. So he got him in January, and then it was like, all right, we are withdrawing from the case. So that's the motion. That's the motion order that was vacated. Trying to see if for Blueface, the notice of motion to Gordon's motion withdraws counsel to Johnathan. So somebody opposed. So the opposing counsel, so the plaintiff's attorney said, hey, we do not want Blueface's attorney to withdraw. So whenever there's a motion, the other side do have a right to oppose that. And that's why you see the notice of opposition there. Because what happens is when you do all of this, it slows down the case. Because now if he doesn't have an attorney, then who's actively working, the case? I'm pretty sure they all know when Blueface does not have an attorney, that is not a good look. And when I say not a good look, I mean that they already know that it's going to slow down the case. He is a defendant. So whenever there's motions, whenever there is a hearing, because he doesn't have counsel, he's going to have to rep himself. So it's like when I draft a motion and I send out that motion, I have to send it out to everybody, to all parties, to all counsels of record. So if Blueface is just a pro se client, self-representative client, that means he got to receive all the documents that are filed in this case. And we know that I don't even think Blue checked his mail or email. I don't know what he does, to be honest. Let's see. The motion to withdraw is canceled. That was actually vacated. Oh man. So it looks as if he has an attorney still. He still has an attorney. Isn't that grand? So they can't they can't leave him because the judge did not grant that motion to withdraw as counsel. So he still has counsel on there. So they vacated that motion. That is interesting. All right. So the last case that we are going to look at is Jackilyn Martinez. Now, her case is a little bit different because she is suing for something completely different. She is actually suing for, oh, let me pull this up, for defamation because your boy just, I don't know, he does the most when he gets on social media. And I don't know what it is that he is trying to accomplish, but it is not a good look. The bad boy, not a good look. You already have two criminal cases you are in. You have a $13 million judgment on top of another judgment from Jasmine Brooks. Bro, you don't need to dish out well, one, he's not dishing out any money because if he was, then them judgment would actually be paid. But bro, what are you doing? Exactly, what are you doing? Now, I'm not going to go through all of this, but I just want you guys to see what she sued him for. So, she is suing him for damages, defamation. If you guys trying to say defamation, I don't even know what the crap she be saying half the time. For false light, for intentional infliction or severe emotional distress, for negligence, and declaratory relief. She is also asking for a jury trial. It says unlimited jurisdiction, case value in excess of $25,000. So this is not saying, well, it is saying that she's asking for more than 25,000, but it's not saying, okay, I'm asking for 25,000 and if I get more. No, it's just that this particular court hears cases for anything that is over $25,000. I hope that makes sense. Now we know what defamation is, but exactly what is false light? And I want to share my screen so you guys can understand what false light is. And I wanted to show you guys versus me explaining it to you guys. So false light is one of several torts that is under the category of invasion of privacy, where a defendant is accused of spreading falsehoods about a plaintiff would be considered objectionable by the average person. The tort typically requires that the plaintiff show that the defendant intentionally or recklessly made a false statement that was made publicly, was a highly or outrageously offensive statement, and caused personal harm to the plaintiff, such as emotional distress. This tort overlaps often with defamation, where the lies spread can also be defamatory. The difference between the two torts vary greatly depending on the jurisdiction, with some states not even recognizing false light. In jurisdiction where false light claims are allowed, the two torts tend to be distinguished by type of injury. False light is supposed to help compensate the plaintiff for emotional and personal harm stemming from the false claims, but defamation tends to be portrayed as compensating for the harm done to the plaintiff's reputation. Another difference between the two is that false light may have lower bar than defamation, as false light only requires false claim to be highly offensive to the reasonable person. Defamation requires more proof than the harm damages reputation. So hopefully you guys got an understanding of what that meant. Now I am going to bring up her actual complaint that she filed in, I want to bring that up, that she filed in the Superior Court. Let me see. You guys can see that. And I'm not going to go through all this. Like I said, there have been plenty of content creators that has gone through this. I'm just going to go through the causes. So here, the first cause of action was defamation. And let me see, on or about December 15th, 16th, 17th, and or 18th of 2023, and continuing, plaintiff became aware that the defendant published, decimated, and communicated with individuals and or a group of persons in social media, including but not to X, formerly known as Twitter, Instagram, and or other social media platform, false and defamatory statements about plaintiff and her child, including but not limited to. I'm not reading that, but you guys can see. And we all know what that meant. He said he had relations with the baby mama the day before the baby shower, was telling him to take a DNA test, and yes, all of that. The defamatory statements would be that, plaintiff had, well, I'm going to do this. The defamatory statements are false. So everything that was said in that prior part is going to be considered defamatory statements. Plaintiff did admit that she had protected relations with him, Blueface, a year ago from, let me see, or in 2018. I'm sorry. One time in 2018. Since that time, she has no interaction with this man. She has not engaged in any type of activity at all with this man. On December 19th, and we all know this, plaintiff's attorney and plaintiff sent defendant a cease and desist letter that he immediately remove all defamatory publications and posting relating to plaintiff, including but not limited X, I still call it Twitter, and Instagram. Those posts that he made between December 15th and the 18th of 2023. That letter also requested that defendant immediately cease from engaging in any further or behavior of any type towards the plaintiff. Do you think this man stopped? The 19th. Oh my gosh. So he went on, I forgot where he did, if he went on or he went on Twitter, and he pretty much mocked her. Then on the 19th, he posted again on the internet. See, he did not take this cease and desist letter seriously. It's one thing when a cease and desist letter comes from the plaintiff, just, as a person, not represented by any, but when it comes from a law firm, now we're going to take legal action. And that is why he is where he is right now with this lawsuit. Warned. It's like sending a demand letter before you file a lawsuit. You pay me my money. If you don't pay me my money, then I'm going to file a lawsuit. Same thing with the cease and desist letter. We're giving you an opportunity to clear up your act and stop talking. You didn't do that, so now we got to take legal matters. So that's that. The second cause of action was for false light. Once again, on these dates, he continued, and he was aware of what he was doing. He published them, he decimated, he communicated with the whole world pretty much. And he kept saying it, and he kept mocking her. Let's see. Now it says the false light created by the disclosure of defendant and those 1 through 100 inclusive, and each of them be highly offensive to a reasonable and plaintiff's position. There is clear and convincing evidence that defendant knew the disclosure would create a false impression about plaintiff with regards to the truth acted with reckless disregard for the truth. So even though Blueface knew it was not true, he continued to do it. People shared it and people commented. false impression that would be created by its disclosure. So he was negligent in determining the truth of the information. So let me see. Defendants. So Blueface and were negligent in determining the truth of the information, or whether a false impression would be disclosure. This is very important. They were negligent in determining the truth. So instead of doing your due diligence and figuring out if it was true, people continue to share it. Yeah. That I hope this wakes up somebody. If you fail to do your due diligence on getting credible, factual information and continue to spread lies because you don't want to do your due diligence, that's a problem. There's clear and convincing evidence that Blueface knew that the disclosure would create a false impression about plaintiff with disregard of the truth. So that is just, with her kid. How do you think she feels in place and people know her? This takes me back to the Fiona Harvey case. Now, I don't know. She's a stalker. But look at all of the things that is happening to her based off of a movie. This lady can't even come out of her house. In that instance, the plaintiff is harmed. She sustained harm to her property, to her business, to her profession, to her occupation, including money spent as a result of the statement. So now I have to spend out of my pocket to go get a lawyer to do the cease and desist. And now this hasn't worked. So now I got to spend my money on litigation. Yeah. Plaintiff has been directly and legally caused to suffer actual damage pursuant to the California Civil Code 3333, including but not limited to a loss of earnings and future earning capacity, medical and related expenses for care and procedures both now and in the future, attorney's fees, and other pecuniary loss not presently ascertained, for which plaintiff will seek leave of court to amend when ascertained. So not only we don't know how this damaged her in the capacity of her earning her living. We don't know what this did to her mentally and emotionally. She probably had to go seek some type of psychiatrist, psychological, mental therapist, whatever the case may be. But she still has to prove up these things. It's not just because she's asking for them or they're saying that, she suffered these damages, she still has to prove them up. She has to prove that she has lost earnings and that, in the future she would lose out on earnings. She has to show that she had medical and related expenses to care for now or in the future. So yes, she's asking for these things, but that does not necessarily mean that she is going to get that funds for those damages because she has to prove that up. Let's see. Plaintiff was rendered sick, sore, lame, disabled, and disordered, both internally and externally, and suffered, among other things, numerous internal injuries, severe fright, shock, pain, discomfort, and anxiety. The exact nature and extent of said injuries are not known to plaintiff, who will pray leave to court to assert the same when they are ascertained. So that means that, this is not something that you can actually determine, but in the event, this is going to take a toll on her if it has not already. But what they're saying is, in the event that later down the line, all of these things come up, she will be able to be compensated for that. Oh man. So that is the second one. The third cause of action is for intentional infliction or severe emotional distress. So once again, is going through the defamatory statements that were said by Blueface. They were false, and it paint the plaintiff in a false light. And because of that, she has pretty much suffered certain emotional distress. I don't know so much of physical, but mentally, yes. Get in the bag, possibly. We sat here, we sent out a cease and desist letter. You didn't even bother to take that seriously. You just really mocked her. All of this that Johnathan Porter has pretty much done, he is going to be liable for this. And he can't say that he did not do it. Okay? There's evidence. And this goes back to having to subpoena his social media. So even though he wiped it off, that doesn't mean anything. There is tangible evidence there showing that you did these things. So that's one part. The other part that she has to do as the plaintiff is she has to prove up. She has to show that she was, emotionally damaged, physically damaged, mentally damaged. That's the only way that this is actually going to work. I don't know how much she is actually going to get for all of this, but your boy was negligent. He was. Blueface didn't have a care in the world of what he did. He didn't have a care in the world. So what she is asking for from the court, general damages in an amount within the jurisdictional limits of this court. So that's anything above 15,000. Medical expenses and related items of expense. According to proof, you always have to prove up your medical. Loss of earnings. You got to show that you lost some money. You also have to show that you are going to lose money in the future. Reasonable attorney fees and costs of said suit pursuant to the California Code. The reasonable attorneys and fees and costs of said suit as specifically provided in. Why did they put that twice? Oh, yeah. So two different. This is the government code, and then this is the code of civil procedure. And I'm sure that the attorney's office will show them the bill. And that's going to be a pretty hefty bill. And here's the thing. This is the difference between civil attorneys and criminal law attorneys. For this particular course of action, um attorneys do not have to be paid up front. Now, if it was a family law case, that's different. But when you're dealing with these civil matters, they work off of a contingency fee. So that means whatever the settlement is, that is when the attorney gets paid. They don't get paid up front. So if they go to trial and they lose, you're just out of money. You have a lot of expenses because litigation is high. But unfortunately, if they go to trial and they lose, then they don't get no money. Now, if they go and do a mediation or arbitration and they end up settling, then they'll take out their percentage and she'll get the rest. Trial is always 50-50. In my opinion, trial is 50-50. I've the biggest personal injury firm that I have worked for. Well, in my opinion, I don't know why that attorney got that case, but he thought it was a good case. It was a car wreck case. The insurer was AT&T. Got to trial and lost because the jury actually went with the defendant versus the plaintiff. And I was like, wow. So ever since then, like if we ever get an offer for settlement anytime before trial, I always try to convince the it just depends on what type of case it is. I always try to convince the plaintiff to settle because it's a 50-50 chance. You might get more or you might lose it all or you might get less. So who knows? So yeah, so a reasonable attorney fees and costs. Let's see, for a permanent injunction against defendants, inclusive and each of them, their successors. Let's see. So this, so a permanent injunction. So that means that they want to enter in, and I'm breaking it down in simplest terms. They want to enter into agreement to where Blueface cannot say anything regarding her, him, or nobody else. He can't defame her. He can't spread false news about her. None of that. He can't do anything that will bring emotional distress, negligence, anything of that nature. So that she said a permanent injunction. Because if it happens again, I'm curious as to how this is gonna work. Well, right now he locked up, so it ain't too much that he can do. But she wants a permanent. She's asking the court for a permanent injunction. And then, in addition to prejudgment interest, punitive and exemplary damages, and the cost of the suit that was incurred. And then we have the demand for a jury trial, which is awesome. But so a lot of these cases like this, you are not really going to see them go to trial. A lot of times they are going to settle when it comes to, arbitration or mediation. But a civil case can settle anytime. Anytime. We've had cases where we will file suit and we're doing all this pre-litigation work and they didn't want to work with us, but as soon as we file suit, the next day they're calling, hey, can we do a mediation? And this is even before we hit the discovery phase, the deposition phase. They are wanting to schedule mediation within the week so they can settle this case. So we don't know, but the way that it is looking, because Johnathan is in the county, I don't know how this is going to work unless the attorney is, they set up a Zoom or a jail call or I don't know, but we shall see. All of these civil cases, guys, I am going to monitor, especially Blueface, not just the civil case, but the criminal case, because I do want to see what is going to happen. On the criminal side, it's it's not looking good for your boy, especially when it comes to the Las Vegas incident, probation violation. But then on the other hand, if you do get out, now you're stuck with all these civil cases. Like, you are 13 million plus in debt. How are you going to get yourself out of that? There is no way to actually get out of that. You are stuck in a $13 million judgment plus, because not just for the nightclub, but also Miss Jasmine Brooks. And then you have the civil suit with Soldier Boy's baby mother. You can't get into any more debt, man. And the likelihood of them receiving any of this money is 0%. I'll give it a 1%. It's really going to hit him when they start freezing his assets. And then what are you going to do, Blueface? What are you going to do? So that is all on the civil side. I hope this was informational. If you guys don't understand something, definitely ask me the questions in the comment. Please give me some feedback in the comments. I will surely respond. Don't forget to like, share, subscribe. Thank you guys for tuning in. Everybody pretty much is going to be the replay gang. So shout out to all of you that is listening to this right now. Enjoy the rest of your weekend, guys. Until then, be blessed, stay safe, and I'm out.